My name is Johanna Keamy with Keamy Tavares Associates in San Diego, California. I've been practicing business immigration law for almost 20 years. This immigration law update will focus on highly skilled workers, business people, athletes, and those that work for them during the COVID-19 pandemic. The information provided is not intended to constitute legal advice, and all information provided is for general informational purposes only. Significant delays are inevitable, but current policy and laws require applicants to maintain compliance with U.S. immigration laws. I'll outline different issues that require attention during the COVID-19 pandemic. Many applicants have asked, what if I'm late filing for my extension or change of status during the COVID-19 pandemic? Applicants should always timely file their extensions with USCIS or for a change of status. The difference between a visa and the I-94 sometimes confuses applicants. The I-94 is the duration of stay authorized when you enter the country. You can download this I-94 on the CBP website, and we'll provide a link below. Also, many applicants ask, can I still enter the U.S. and work if I'm from Canada or Mexico? Current travel from the southern and northern countries have been restricted. However, individuals traveling to work in the United States is considered essential. Please be advised, however, that some CBP ports are for the moment, and unless directed otherwise, continuing to process L1 and TN applications, while others are not and may deny the application for not being essential. This issue requires continued monitoring. Are you from a visa waiver country and could not depart the United States due to the COVID-19 pandemic? Please be aware that those individuals who find themselves unable to depart the U.S. before the current period of admission will end because of COVID-19 related issues who were admitted to the U.S. through John F. Kennedy International Airport and the Newark Liberty International Airport only can contact the Deferred Inspections Office at JFK starting Monday, March 16, 2020. Individuals and their attorneys may be asked to provide the original departure flight itinerary along with the new flight itinerary. Please keep in mind this only concerns JFK and the Newark Liberty International Airport. Many applicants ask whether they can continue to file for extensions under the H-1B program. Employees in the H-1B program may have their status and employment authorization extended if their employer timely files a Form I-129 to extend the employment or a new employer petitions to become their employer. Remember, during COVID-19, LCA requirements still apply, and the employer must post a notice at the work site stating that it has filed a labor condition application. The employer is responsible for posting the notice of the filing of the LCA at 2 conspicuous locations at the place of employment for 10 days, or electronically providing the notice of the filing of the LCA to all workers at the place of employment for 10 days. Many applicants wonder what will happen if they're laid off from employment under the H-1B program during the COVID-19 pandemic. Remember, the Department of Labor requires H-1B workers to be paid the required wage rate for all non-productive time caused by conditions related to employment, such as lack of assigned work. At any point when an H-1B employee is not performing work or not in productive status due to a decision of the employer, the employee must still continue to receive the wage listed in the labor condition application filed by the H-1B petition. The requirement stands even if U.S. workers aren't paid during such times. We are in need of guidance on this issue concerning the COVID-19 and required federal and state mandates forcing employer decisions. A viable solution when workload is reduced is filing an H-1B amendment to change the employee's status to part-time. If the employee is terminated, USCIS policy has been to allow 30 days grace period for filing of a change of employer. Under portability, the H-1B applicant may commence work immediately upon the filing of the H-1B application. Please keep in mind that the ability to port to another employer upon the filing of an application is not available under other non-immigrant classifications, such as the P1 Athlete Visa, the E2 Treaty Investor Visa, TN under NAFTA for skilled workers, and the L1A and L1B intra-company transferee, and O extraordinary ability cases. Please note also that premium processing is currently suspended. Right now, applicants in these non-immigrant classifications have to file regular processing and sit and wait on adjudication of their file, and they are not permitted to work during this period. Many applicants are here on an E2 Treaty Investor Visa, and with the E2 Treaty Investor Visa, the applicants must have a company that continues to be viable and employ U.S. workers. Unfortunately, with the COVID-19 pandemic, most businesses have been forced to close their doors. And obviously, these applicants are wondering what they're going to do as far as keeping the business open, and especially when it's time for renewal with USCIS. At this time, we're waiting for further guidance, and hopefully we'll have more on this subject. But for the time being, if an E2 Treaty Investor applicant needs to perhaps if they have a restaurant and they need to start some online takeout, that would seem to be in line with the business and should not cause any problems with the renewal process. Many applicants are wondering what's going to happen to their work authorization when in fact their EAD card has expired but they've timely filed for renewal. Please note that the Department of Homeland Security will allow for automatic EAD revalidation as long as three criteria are met. First, the applicant must have timely filed for the extension. Second, the code that is on the I-797 receipt notice must match the code that's on the face of the EAD document, and the applicant's code must be allowable under the regulations. We've provided a list below. If you are in the United States as a highly skilled worker, an investor, an athlete, or some other non-immigrant classification, I know that you are talented, strong, and you've worked really hard. My thoughts and prayers are with all of you during this COVID-19 pandemic, and I know that all of you will brave through it. Thank you for watching this video. If you have any additional questions, feel free to contact me through my website and the email link below.